Well, trusts are often used in agriculture to ensure the operation is passed down to the next generation. However, with a variety of options, issues can arise over the legal responsibility of a trustee to other beneficiaries. Well, Roger McEowen with the Washburn School of Law joins us now with some guidance in today's Rural Money segment. Well, Roger, what are the general responsibilities of a trustee to a trust and its beneficiaries?
Good to be with you, Tammy. And yes, trusts are used rather heavily in agriculture as well as in non-agricultural families and small businesses. But the basic duties are, I think, threefold when it comes to a trustee with respect to the beneficiaries. They have to be loyal, they have to be impartial, and they have to act in prudence with respect to the way they manage the trust assets and the income. So they have to look out for the interests of the other beneficiaries, even if they themselves are a beneficiary. So all three of those duties are contained in any particular state's trust code, and those are very important duties.
And if the trust gives the trustee full discretion over trust assets and income, do those duties still apply?
They do. You can't override those statutory duties. You can't override trust law by putting a provision in a trust that says that the trustee has full discretion over trust assets and income. You can't, it's not permissible to interpret that in a way that would allow you basically to preclude the other beneficiaries from benefiting from the trust, even though it has fully discretionary language in it.
Now, can you give us an example?
Yeah, there was a really big, important example in a Kansas Court of Appeals decision that just came down late last week, and it involves a farm setting. Mom was the surviving spouse. She had 5 kids. One was to be the farmer and inherit the farmland, and the other kids, as the trust said, were not, it was a trust created under her will, were not to have any interest in the farm ground or the farm equipment or the cattle. And what Mom had were tracts of land in 2 counties. They had a lot of debt on them, which was unfortunate, but she had cattle and farm equipment, and then she had oil and gas interests, and that's a big part of agriculture in the western part of Kansas. And all the property except the farmland went into the trust. The one son was deeded a half interest in the farmland with another brother, who then deeded his interest over to that brother who was the trustee, by the way, of the trust. And it had fully discretionary language in it. And so what he did was he used that language to say, well, I can take that oil and gas royalty income that's in the trust, and I can use that to pay down the debt on the land that I own personally because I have full discretion. That's what the trust says. Well, long story short, the Kansas Court of Appeals, reversing the trial court, said, no, you can't do that, and you have committed a breach of trust, and now that all has to be repaired. And so it's back to the trial court to figure out how he replaces what he replenished from the trust, even though it's already been paid down on the farm debt. So it was a real mess.
Yeah, that's going to make for interesting Thanksgiving dinner conversation at that family table, isn't it? So what's the big takeaway from that Kansas case?
Well, I think the big takeaway on this is more so for drafting attorneys and other professionals that are advising farmers. When you draft these trusts, just if the client says, I want a trust, just don't pull boilerplate language off the shelf and use that. Sit down with the client, explain to them what terms mean, what are they expecting from the trust, what does this discretionary language actually mean? Because the last thing you want is what resulted in this case of family members suing other family members. Everybody's mad at each other, and now you've got an absolute mess. So we have to, as attorneys, we have to take care to make sure clients understand what the documents mean to the client that we're drafting for them. And unfortunately, it doesn't appear that was done in this case.
All right. Well, that's Roger McEowen with the Washburn School of Law. Appreciate your insight and takeaways from that case.